if you, via email, and if you have questions or something's unclear as I'm going through this, feel free to put it in the Q&A or the chat section, and I'll try to get that answer. And with that, I will share my screen. And we're live. All right. All right. So we do these every week. And two questions I had. Oh, and I always start with a positive focus. I almost forgot that. How could I forget a positive focus? My son, Ryan, who's in Boy Scouts, is going away on his first camping trip without mom or dad. So he's gonna be gone for 6 days, which is pretty crazy to think about. So pretty excited for him, and should have a good time. All right, so we had 2 questions submitted ahead of time, and if you do have questions, pardon me, feel free to put them into the Q&A section. And the first question: saw an article about caregivers and elder abuse. Is this because people are not able to take care of themselves and don't have a POA, and the judge appoints someone, now a stranger is managing the finances, so how do we protect against this? So this is a common question, and it's something that as it's almost part of the long-term care discussion of we're living longer than ever, and sometimes the body is doing better than the mind. And so whether it's dementia, just the frailties of aging, we might need some assistance. So there's a couple different, I guess, scenarios where this comes into play. One is you've done no planning, so no rule book, right? And what I mean is you don't have a trust which can manage your affairs while you're alive as well as upon death. You don't have a durable power of attorney. We typically just call it, to simplify things, financial power of attorney. So you don't have a financial power of attorney, you don't have a trust, and now you get a knock on your head, you suffer from dementia, just old age, you can't manage your affairs anymore. So what would happen? Sorry. So what would happen is someone would have to basically go to court for you. And this is called probate. And we can have probate while upon death. That's the one that most people are familiar with. But we can also have probate while you're alive. And we call this living probate. And the technical term of this is either a guardianship to make decisions with regards to your care. And if you have less than, I think it's $100,000, that would be through a guardianship. And then also, if you do have money, then the courts would appoint a conservator. I'm spelling that wrong, but a conservatorship or a conservator. And who are these people? Well, it could be family. It could be family. But a lot of times if you're at this point, or it could be friends, but if you're at this point, then what's going to happen is typically the court's going to appoint one. And typically it's going to be an attorney. And so this is where there's been some cases even in Michigan where the person the court has appointed has taken advantage of the senior, and there should be checks and balances there, but it does happen, whether it's fraud or just taking advantage of that person. So that would be one way that we get into a guardianship conservatorship where now someone's managing the finances, is that if you don't have your own rule book, you don't have a financial power of attorney. This is a document where you appoint someone to make financial decisions for you. Likewise, a trust, if we have assets owned by the trust, whoever you appoint as a successor trustee could manage the assets in the trust. So again, most people want to avoid this living probate where, first of all, it's monitored by the court, so that's a big pain in the butt. But then, especially if we get down to court-appointed guardians and conservators, I'm not saying it's common by any means, but there have been circumstances where someone's kind of defrauded a guardian or conservator. So that's kind of one situation. Excuse me. Another situation would be where we're suffering from dementia, Alzheimer's, just kind of starting to make poor choices. And someone can kind of get in there and kind of plant ideas in your head or make you do something kind of silly with your money. I've seen this in my practice where I had an individual, very intelligent, he was an engineer, ended up getting defrauded from individuals in Haiti where he was sending them gift cards, like hundreds of thousands of dollars worth of gift cards. He would argue that it was a good investment at the time, but the family, and any reasonable person would say that it wasn't a good investment. So the interesting thing with a financial power of attorney is that it doesn't take away someone's individual to make, or someone's ability to make their own poor individual decisions. So understand that a financial power of attorney doesn't take away your ability to make poor choices. But that's where a trust can. So in that situation, what we did is we set up an asset protection trust because the family was concerned about long-term care costs, but also we set it up in such a way that he was not the trustee. We had someone else managing it. So even though he was technically the beneficiary, he wasn't managing the assets in the trust. And kind of think of a trust like a piggy bank or a suitcase. Typically, you would set up the trust, you would be managing the assets, you could take the assets out. But in this situation, we set up the trust and we just had another family member managing it. So I guess getting back to the original question, how do we protect against this? There's no perfect magic wand answer, but what I would suggest is by creating a rule book, okay? Having a well-drafted estate plan, where we map out who's going to make decisions if you're unable to, and having the right people, right? We could have the best legal plan in the world, and if you've appointed your son or daughter as your successor trustee or power of attorney, and they're a horrible person, God forbid, then even a well-drafted estate plan isn't going to protect against that. So it's really dependent on the people who are surrounding you, but you're going to be in a much better position if you do have that estate plan. All right, so hopefully that was helpful. All right, so let's see, a chat. I heard a couple of questions coming in here. All right, let's do the second question I have listed here. What's this question? I heard that trust income reaches maximum tax rates. Okay, we'll talk about that one in a second. All right, so let's knock off this second question that was submitted ahead of time. I want to create a lifetime of income for a beneficiary upon death. How would I go about doing that? There's different ways to do it. Again, getting back to kind of through the legal channels, what we would probably want to do is create a trust, and instead of upon death just going outright to that individual, that pillowcase of money approach, instead we would hold it in trust for their benefit. We call this a separate share trust or legacy inheritance trust. And so this trust or safety deposit box or trust for the beneficiary, we could build certain rules around it. So we could say that income, maybe just the income comes out of this and the principal remains. We could say, you know what, maybe 4% per year comes out of this. Or I've had families say, this isn't answering the question, like 10% per year for 10 years. The idea is that it's basically liquidated over a period of time. But if we're looking at creating a lifetime of income, then we can just direct the trustee to do one of these things. And maybe direct it, okay, 4% a year comes out. Now, taking it one step further, what we also could do is look at upon death, what we could do is get what's called a single premium immediate annuity based on the beneficiary's life. And think of this as almost like kind of Social Security. You pay money in for your lifetime, and then at a certain point you flip a switch and now it becomes annuitized. And so we could do a single premium immediate annuity that based on the insurance company and the age of the individual, the insurance company will guarantee a certain amount of income per year or per month for life. Obviously, the younger the individual, the lower the amount. The older the individual, the higher the amount would be. So we could do it from a legal perspective and just leave the trustee up, leave it up to the trustee to decide how to invest to get to that point. Or if you really truly want a guaranteed lifetime income, then you would look at a single premium immediate annuity, which is basically similar to, say, Social Security or pension. It's just taking a lump sum of cash and turning it into an income stream for life. So hopefully that was helpful. Any questions on that? Nope. Okay. So I just had 2 questions submitted. Let's do this one from Ed. So third question here, FIAs can be funded with qualified or non-qualified funds. Advantages of each type of funding. IULs, I presume, can only be funded with non-qualified funds as proceeds are tax-free. Okay, so we're talking about 2 different investment tools. We're talking about a fixed index annuity and a index universal life insurance. They're similar but different. Big thing with IUL is there is this life insurance component to it. And a lot of times we're using this life insurance piece because it qualifies for what we call 7702 in the tax code, where we can, if we wanted to, we can create tax-free income. And there's some other things that go along with IUL. It can be tax-free income. We can get a death benefit out of it that's larger than what we put in. So some people use it for legacy. Also, long-term care, that death benefit could double as a long-term care benefit. And then we have fixed index annuities. This is typically, so I talked about a single premium immediate annuity. That's kind of the standard. When people think of annuity, they think of lifetime income. That's what the single premium annuity is. Fixed index annuities can be geared towards different things, but typically the key components are we want our money to grow and we don't want to lose what we put into it. This also has those components as well. That's what the I part, index universal life or fixed index annuity. They both offer growth and safety. So the question was, where do we invest in these? And so we have to define what's a qualified account. A qualified account would be things like an IRA, 401k, 403b, Roth. All of these have a certain tax qualification. That's why we call these qualified accounts. Some of these are pre-tax. Roth IRA would be post-tax and it grows tax-free. So the fixed index annuity can be invested in either qualified, and then we also have what we call non-qualified. These don't have any type of kind of tax qualification to them just by the nature of the account. So this would be like your checking account, your savings, your money market, brokerage accounts. And interestingly, technically a IUL, which grows tax-free, has to be funded out of a non-qualified account. Qualified accounts, and also we could have fixed index annuities over here as well. Qualified accounts cannot hold IUL. but they can hold fixed index annuities. So we could put a fixed index annuity inside of a traditional IRA. We could put a fixed index annuity inside of a Roth. But a lot of times people have a lot of pre-tax dollars. So the way that we fund the IUL, if we were to do it, is pull the money out of the IRA, pay the tax, move it into checking and savings, and then from there, we would pay the premium on the IUL. So that's, I presume, can only be funded with non-qualified funds and proceeds. Yep. And then again, the big thing about the IUL by its nature is that its growth is tax-free. We can have a fixed index annuity that grows tax-free, but it would have to be inside of a Roth. So, and not everyone can do Roths. So that's why a lot of people look at IULs as kind of rich man's Roths. Okay, so I answered that question. After you create a FIA, can you later convert some of it to IUL? Yeah, so let's say you put in 500,000 to a fixed index annuity, and then let's say a number of years it grows. Okay, you wouldn't do it like right away, because one of the trade-offs with these are sometimes it takes some time. We wouldn't want to move into a fixed index annuity or IUL right away, or excuse me, move into it and then pull all the money out right away. Like that would be a mistake. But let's say we do a fixed index annuity, and then actually there's a sorry, I got something stuck in my throat. One sec. All right, sorry about that. So let's say we funded a fixed index annuity. One of the things we can do is take out 10% a year without any penalty. So that'd be $50,000 coming out each year. And then that could be used to fund the premium for the index universal life. So after you create a FIA, can you later convert some of it to an IUL? The answer is yes. We would just have to make sure that we fit the plan together correctly. And again, that's why we always figure out, okay, what are the goals? What's the best strategy to help you achieve the goals, and then put together the right tools. Is there any one-time payment for long-term life insurance? The answer is yeah. So technically with IUL, we fund it over typically a period of 5 years, but we could do a one-time payment to, say, like a fixed index annuity, or we could do a one-time payment to the IUL. And what they have is a portion of it is sitting in a fixed account that might earn 2%. And that 2% then funds the cash value life insurance. So technically, no, there isn't really a good, well, technically, yes. Yes, we can do a one-time payment for long-term or permanent life insurance. Let me clear off these questions. If I have a $300,000 universal life policy that gets converted to paying for long-term care, and the long-term care costs exceed the original $300,000 life insurance policy, will the long-term care payments continue to be paid by the life insurance policy? What we're talking about here is we have, so let's say we put in $300,000, and I'm oversimplifying things. Let's say that gets turned into $700,000 worth of death benefit or long-term care. So you're either going to need the death benefit or long-term care benefit, or some combination of both. So the question asked is, what happens if we use up all of this for long-term care? Does the long-term care benefit continue? The answer depends on the type of policy, the way the policy is structured. What we would have to do to get that long-term care benefit to continue would add on a continuation of benefits option to that long-term care. So if long-term care is our number one concern, then typically we would add on this continuation of benefits option. And I apologize, we use a ton of acronyms. Like I'm looking at this, COB, what's COB? But again, it's I'm kind of doing this on the fly. So it's continuation of benefits. So if the policy says that it's going to pay out, say, $5,000 per month, and we've exhausted all of that at that $500,000 per month, if we added, when we set up the policy, this continuation of benefits, then this $5,000 would be unlimited as long as you were alive. Now the death benefit would go away because you've used up that bucket. So hopefully that was clear. FIAs generally don't have fees, do IULs. So you're right, fixed index annuities, there's no fees to them, no cost, versus variable annuities. There are annuities that do have fees. Likewise, no fees for a single premium immediate annuity. IULs don't have fees per se, but they do have expenses because that IUL, there has to be some type of life insurance component to it. So you're going to have a mortality expense, right? So that mortality expense, that's really what your death benefit is. And depending on how the policy is set up, that death benefit or mortality expense goes to fund the death benefit and then also any long-term care benefits. So deciding whether we want a fixed index annuity or IUL, whichever, like which one's better, neither is better. They're both tools. It's just, what are your goals? Let's pick the right strategy and then pick the right tools. They're just similar yet different. So every situation is a little bit different, but fixed index annuities don't have any fees or expenses tied to them typically. IUL will have mortality expense tied to it, but that's going to fund the death benefit and long-term care benefit. I assume you'll ask. Yep. Okay. And all right. Let's see. Another question: is there a way? So the question is: have a LLC? Is there a way to save in taxes from LLC income? Well, I'm not a CPA. We have a CPA with us. I don't have any magic wand answers, just other than taking business deductions, looking at what other things you have going on. So the question is, you have LLC income, is there a way to save? I don't have any magic wand answer other than we would take a look at your tax return and see if there's any opportunities there. So, okay, I heard that trust income reaches maximum tax rates at about 11,000 per year. So we're talking about trust income, 11,000 per year. Is it better to allow a beneficiary ability to use income at early age, like 18, and then set up to receive principal at 25, 30, 35? Okay. So, upon death, what happens? And the concern is trust income. Because the way it works is once a trust gets over $12,500, if I'm not mistaken, of income, then you're at the top 37% tax bracket. Versus a married couple, you have to get over like 600,000 of income to get to the 37% tax bracket. So with that, most of our trusts do not keep the income inside of the trust. So upon death, we kind of have different ways to handle things, but kind of the old way was to say that the income goes out to the individual, and then the principal would go out at 25, 30, 35, with the idea that we're protecting against the poor mismanagement of the child. So yeah, we would almost always have the income coming out and the principal would be held. But the concern with this is what happens if they get a divorce at age 36? Half that money could be gone. What happens if they pass away at age 36? All that money could be gone. So a lot of times what we're doing is we're saying, you know what, let's keep it in trust. And then at maybe age 30, now they can step in and manage their trust, where if they want to, they can open up the trust and take the principal and income out, but they're not forced to, because by saying 25, 30, 35, you're just launching a pillowcase of money. And then if they get divorced at 36, half that money could be gone. Versus here, we're giving them an opportunity for a lifetime of asset protection. But either way, the trust income, because we want to avoid this, we almost always have the income coming out. Or if not coming out, at least taxed on their own personal income tax rate versus trust at a tax rate. So doing things like a K1 out of the trust. So it shows that they have the income, but if we wanted to keep the income in, we could. They would just have phantom income that they would have to pay tax on. Or we could take the income out to pay the tax. So but that was good. Okay, all right. Any other questions? Let me just see, check the chat, check the Q&A. I think I answered everything. All right, well, I appreciate it. I always really enjoy these. I love the questions that come in. Thank you. Thank you. Yes, you're welcome. Thank you. All right, with that, make it a great week. Take care. Bye-bye.